The United States Department of Homeland Security has withdrawn the Trump-era rules regarding the definition of public charge. In this video, I will explain exactly what that means and how it affects applications for immigration benefits going forward. My name is William Kovatch, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. Let's start off by talking about the law. The Immigration and Nationality Act provides that a person who is likely to become a public charge is inadmissible. And what this means is that anybody who is seeking to immigrate to the United States cannot be found to be likely to become a public charge, or that person cannot get a visa. That could mean that a person is denied permanent residency. But Congress has never defined the term public charge, which means that, as a general matter, it's up to the executive branch to interpret what the words public charge means and how the administration is going to enforce the statute. The Trump administration did exactly that when it published new regulations addressing the public charge rule in August of 2019. But the way that the Trump administration interpreted the term public charge ran counter to long-established policy of what the term should mean. Generally speaking, we do not want people to immigrate to the United States and then become dependent on the government. And that is generally what the term public charge is meant to address. In 1999, the old Immigration and Naturalization Service, or the INS, published official guidance in the Federal Register on how to define a public charge. The INS defined public charge as a person who is primarily dependent on the government for subsistence, as demonstrated by 1. The receipt of cash assistance or income maintenance, or 2. Institutionalization for long-term care at government expense. And while the INS was abolished, the agency that inherited its functions, the U.S. Citizenship and Immigration Services, continued to follow this guidance. That is, until 2019. USCIS, now in the control of the Trump administration, decided that it wanted to interpret the term public charge much more broadly. Instead of considering solely cash assistance programs, USCIS announced that it would consider a whole host of other government benefits in determining if a person would become a public charge. This included programs such as nutrition assistance programs, commonly referred to as food stamps or SNAP benefits, housing assistance such as Section 8 housing, and even medical assistance such as Medicare, a sort of government health care insurance. USCIS said that it would look at the past 36 months and see if a person who is applying for a green card has received any such government benefits. If a person received 12 months in the aggregate of any of the specified public benefits, then that person would be considered likely to become a public charge. This was a regulation that alarmed many immigration advocates. It was argued that it would have the effect of dissuading anyone who intended on applying for a green card on accepting any form of help from the government. For example, in the past year, many programs that tested for COVID-19 were funded and administered by state governments. Intending immigrants living in the United States were afraid that by even accepting a COVID-19 test, that they would be prohibited from being able to obtain a green card. Other immigration advocates noted that the goal of many of the government programs was not necessarily to support the poor. Nutritional supplement programs such as SNAP or food stamps is meant to ensure a minimal level of nutritional standards for Americans. As such, SNAP or food stamps is not necessarily limited to people who are living in poverty. Therefore, immigration advocates sued the Trump administration across the country over the implementation of its new public charge rule. The lawsuits occurred in various U.S. federal courts across the country. The results of the litigation were mixed. Some U.S. courts of appeals, such as the 2nd, 7th, and 9th Circuits, found against the Trump administration. Those courts issued injunctions preventing the Trump administration from implementing its new rule. Other, more conservative circuits, such as the 4th Circuit, found that the Trump administration had the authority to adopt its chosen interpretation of the term public charge. Because of this split in the circuits, the Trump administration had taken steps to pursue the matter before the United States Supreme Court. For example, after the 7th Circuit issued a preliminary injunction blocking the new rule, the Trump administration sought a stay of the injunction pending an appeal to the U.S. Supreme Court. This was back in November of 2020. But the fact that none of the cases had yet reached the Supreme Court gave the incoming Biden administration some discretion in determining how to address the situation. Essentially, the Biden administration chose not to pursue the various appeals from the U.S. Circuit Courts to the U.S. Supreme Court. Instead, the Biden administration has chosen to adopt the reasoning of the 7th Circuit, one of the circuits that found against the Trump administration, in order to withdraw the Trump-era regulations. In February of 2021, President Biden issued an executive order, and through this executive order, he had his administration review the various immigration regulations that were issued under the Trump administration. On March 9, 2021, USCIS decided that it was going to officially withdraw the regulations governing public charge from the U.S. Code of Federal Regulations. The announcement was published in the Federal Register on March 15, 2021. So as a practical matter, what does this mean? What does it mean for people who may be applying for immigration benefits either now or who may have an application that's currently pending? For one, USCIS announced that it would return to the interpretation of public charge that was adopted by the INS way back in 1999. No longer will the 2019 interpretation govern. This means that in order to be considered likely to become a public charge, a person must either be receiving cash assistance from the government, such as SSI or Supplemental Security Income, or be institutionalized in a long-term care facility at government expense, that is, receiving Medicaid in order to live in a nursing home. In order to enforce its new interpretation, the Trump administration adopted a number of forms requiring the disclosure of much information in order to determine if an intending immigrant was likely to become a public charge. Key among these was a form called an I-944. It was entitled the Declaration of Self-Sufficiency. Pursuant to the new Biden administration rules, this form is now being eliminated altogether. Other forms, such as the I-129 petition for a foreign worker, are removing questions that asked about the receipt of public benefits. USCIS has issued further guidance on their website, and we will have a link to their website in the description box below. Specifically, USCIS states, applicants and petitioners should not provide information or evidence related solely to the public charge final rule, that is, the rule from the Trump administration. That means that applicants for adjustment of status should not submit Form I-944, Declaration of Self-Sufficiency, or any evidence or documentation required by Form I-944 when they file their Form I-485. The Form I-485 is the adjustment of status application. It's what's used when an immigrant is applying to become a permanent resident while they're in the United States. USCIS also announced that if an applicant or petitioner has already filed information pertaining solely to the Trump-era public charge rule, the agency will not consider that information. USCIS further advised that any applicants who had received a request for evidence, commonly referred to as an RFE, or a notice of intent to deny, which is known as an NOID or a NOID, and those correspondences requested information solely relevant to the public charge rule, do not need to provide the information requested. Although, if you have received an RFE or a NOID, you should review those documents very carefully. Applicants will still be required to provide requested information that's not related to the public charge rule and provide that information in a timely fashion. If you have an application pending and you received an RFE or a NOID, your best bet is to consult with an immigration attorney to make sure that you are properly responding to USCIS's requests. In a more broader context, this action by USCIS, I believe, gives us a clue into how the Biden administration will handle not only the public charge rule, but other restricted rules that were adopted by the Trump administration. In particular, in the last year of the Trump administration, immigration officials adopted numerous regulations making it more difficult for people applying for immigration benefits. For example, there were changes to the regulations concerning when a person who is applying for asylum could apply to receive the legal right to work in the United States, a work permit. And these rules made it much more difficult for an asylum applicant to receive their work permit. The Trump administration also adopted the Remain in Mexico program, a program that is deceptively called the Migrant Protection Protocols, or MPP. Almost all of these new rules and regulations were subject to litigation, and the Trump administration lost many of the cases in court. It is my belief that based on President Biden's executive order to review various Trump administration rules and regulations regarding immigration, that the Biden administration can choose not to pursue the appeals of those cases that the Trump administration lost either in the U.S. district courts or in the U.S. courts of appeal. The Biden administration can then use the federal court decisions that already exist as the vehicles to publish further notices in the Federal Register, officially withdrawing the Trump-era regulations from the Code of Federal Regulations. In particular, I would look next for the announcements regarding Trump-era regulations concerning the administration of asylum law. I do believe that in the near future, much of the rules concerning applying for a work permit, for example, will be withdrawn and that we will return to the procedure that existed before 2020. I will keep an eye on these issues as they develop, and of course, we'll report on them once USCIS issues any official action. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.